Shelter is a basic need for human sustenance. Right for a living person, everyone deserves a place to live. So why are some people evicted? Why are their houses demolished? What is the law and policy regarding this issue? What is the way forward in the plight of squatters? Assalamualaikum, Tachahau, Vanakkam. Today we are here at a very prominent location in Gombak where a group of squatters have taken over a state land and have making it their own. So today we will see and visit the squatters and see the plight and what makes them legal or illegal in Malaysia. Let's go. We are now going to interview one of the squatters who has been living in this place, Mr. Hakim. Not his real name. So Hakim, cik dah berapa lama duduk sini?
Dalam 20 tahun jugalah bang.
20 tahun. So apa perkembangan kat sini? Sana duduk sini semua?
Setakat ni kita, ini je lah, kita ada tanam pokok. Lepas tu kita dah sebalik dalam duduk sini kan. Jadi kita pun dah buat satu macam kebun kecil kat belakang tu. Kalau abang nak pisang goreng nanti memang kita orang boleh buat bang.
So cik dapat kebenaran siapa untuk duduk dekat tanah ni?
Tak pastilah bang. Memang saya dengan keluarga saya ikut bapak saya je duduk sini.
So, as we can see, Hakim has been living here with his family for generations without the permission of the state authority. We are now going to interview a neighbour of Mr. Hakim, Mr. Iman. How are you today?
Alhamdulillah.
So, saya ada soalan untuk cik. Selama cik duduk sini, pernah tak ada authority datang? Polis ke?
Setakat ni memang kami tak terima siapa-siapa lah daripada state authority itu kami tak terima lah. So memang kami duduk ni memang dah lama. Memang dari 10 tahun jugalah kat sini. Memang tak ada siapa yang menghalang lah, kuat kuasa ke tak ada. Memang dari keluarga semua lah.
So kalau ada penguat kuasa yang datang, cik nak cakap apa kat dia orang?
Bagi saya lah, sebab ini memang tanah saya. Saya yang jumpa pertama. Memang kalau semua saya dah bina. Ini semua saya bina.
So, Mr. Iman came to this land and assumed it was uninhabited. He built his house and planted many trees and plantations. Mr. Iman assumes that he is now the rightful owner of the state land. We are now going to meet with the land officer for the state of Selangor to discuss on the law and policy of squatters in Malaysia. Encik Zaid, welcome.
According to our national land code, there is no clear terms on squatters mentioned in this land code, but there is a term called as adverse possession and also unlawful possession. And according to section 48, national land code allocates that there is no adverse possession against the state. And also we can refer to section 425 of national land code mention that unlawful occupation of state land is an offence. Adverse possession refers to a situation where a person who have no formal ownership of the land or any areas, but their rights may be upheld. And regarding the policy of squatters in Malaysia, there is this one policy called as Sifar Setinggan or Zero Squatters. This policy targets to reduce the amount of squatters and solve the problem of the illegal possession of the land by these squatters. One of the methods under this policy is by doing the census, or we call in Malay, which is bancian, to know and calculate the exact amount of squatters and will be placed to a new legal housing.
So now we have learned on the law and policy on squatters in Malaysia. Now, live on scene, we go to Jannah on the report of the latest court case. Back to you.
understand better the law and policy regarding squatters in Malaysia, Mr. Sharil has the explanation regarding the latest case, which is Datuk Bandar and another against Tan Poh Hua.
Regarding on the case or the principle regarding on the adverse possession recently is we can find in Datuk Bandar KL and another and Tan Poh Hua 2018. So basically this case was tried in 2018. So the plaintiff was the owner of a piece of land which occupied by the defendant. So the plaintiff intended to develop the land into a housing project. But the defendants, which is the squatters, told the plaintiff they cannot do so because the defendant alleged that they occupied the land from their ancestors almost 40 years before the plaintiff became the owner. So these squatters alleged that they're very promised by the mining company, but nothing was done towards it. So, and the authorities seems no objection by the occupation because water and electricity was supplied to the house, i.e. supplied to the squatters. So the court held that even if the allegation was true, the defendant was still irresistible to the squatters. So the defendant had no right title and or even interest in the state land. So on the part of no objection of the authorities, there was no express representation or assurance given to the defendant by the government. So the court added that in this case, that the defendant must vacate the said land and damage must be paid to the plaintiff. So this case, squatters have no right entitled to the land.
In another case of Tenaga Nasional Berhad against Bukit Lenang Development, in this case, the appellant supplied electricity to a vacant possession without the consent of the owner of the land that has been occupied by the squatters. The Haikal decided that the appellant was held liable for trespass because they had no authority to do so. This is because the consent that was given to them was given by the squatters that was considered as unlawful occupier. This case was then appealed by both parties. And what was the decision next?
Basically, on appeal, the squatters was allowed to stay on the said land, right, until the proceeding commenced. So during this time, the appellant supplied the electricity to the squatters. So the issue in this case, there are two. So firstly, whether the squatters has right to stay on the said land due to prior consent of the earlier owner. So basically, at the High Court, the squatters cannot stay on the said land and they appeal. So the second issue, whether the Tenaga Nasional had duty to supply electricity to the squatters pending trial. So basically, the federal court dismissed the appeal. So the first issue that the court laid that the squatters had no legal right to occupy the subject of land and prohibiting them from occupying the land. So, and the court gives the right to the owner to easily remove the squatters. So the court upheld that the issuance given by the High Court on the mandatory injunction to demolish a house or buildings on the said land. So that was the first issue that mentioned in this case. On the second issue, which is on the part of the Tenaga Nasional, the court laid that there were trespassers, basically. This because the appellant were not the party of the stay order pending trial. So it was obtained by the squatters and also the owner. And even if the squatters had opportunity to stay on the state land pending trial, but the stay order did not provide the duty to the appellant to continually supply electricity to the squatters without the owner's consent. So from this case, it's established that the squatters had no right over the land without going through proper procedure or way under the code. So even if it was temporarily allowed by the court to the squatters to stay on the said land pending trial, they still cannot, they have no right to enjoy the electricity given by the Tenaga Nasional, and Tenaga Nasional had no duty to supply the electricity to these squatters.
It is true that adverse possession is statutorily not applicable in Malaysia, so we still believe that alternative solution should be resorted to solve this never-ending issue in Malaysia.
As far as my observations and experiences are concerned, I think there are few suggestions that can be made in order to improve our current system of squatters in Malaysia. So the first one, I think we should enact national laws and policies which inspect and parcel, protect and secure the fundamental liberties of these squatters. Under two conferences that has been signed by Malaysia, which are the United Nations Conference on Development and Environment as well as the United Nations Commission of Human Rights, both of these conferences criticize the forced eviction as a violation to human rights, and people should be protected against this law. So I believe that even if the squatters are in breach of laws, they should be offered more human ways, following both conferences above. Hence, the law of forced eviction should not be promoted. Instead, it should be the last resort in ensuring fundamental liberties are protected. This is also important to reduce poverty. So most of the squatters are suffering from financial burden and often leaving them in extreme poverty and destitution. So this is because they are required to leave the place of their home or of their so-called home without proper planning or adequate compensation.
This is the government should also empower the current resettlement project that has been done following the zero squatter policy. There are so many initiatives that has been done by the government, and one of it is the People House Project, or also known as PPR. So this PPR policy calls for an improvement to increase the rate in eradicating the squatters in Malaysia. For example, the government should increase the allocations of budgets for the People House Project. This is to let more squatters from low-income class to receive benefits from this project. The second one is the cost of PPR should be lowered. From the previous related studies, it proves that the main reason why the squatters are reluctant to move from their squatter area is plainly because they could not afford to purchase even the low-cost housing. It means that even though the resettlement project has been subsidized by the government, the price of low-cost housing are still beyond their affordability. So this call for the governments to reconsider the current price and look for ways to reduce them. On the other hand, the government also must improve the selections of locations for resettlement. This is because most of the resettlement areas are quite far from the city, when their residency should be close to their workplaces and schools. The relocation places should be adequate and easily accessible in basic necessities and infrastructure. Another way is to extend the rent-to-own scheme to the housing initiatives under the government. So currently, the government has been working with the private financial institutions to provide the property seekers for 5 years rent with the option to buy the house at the price stated in the agreement. So this scheme can be extended to government low-cost housing initiatives. The squatters that can afford to buy a house immediately may resort to this method. This will help them reducing their financial burden and help them plan their finance to buy the house in 5 years. Last suggestion will be by promoting the temporary occupation license, where the state government may grant the TOL to the squatters, and this will help them to stay legally on the land. This can be considered as a temporary place and preparation for them to improve their financial burden. Through this way also, it can be considered as a win-win situation to the government because they do not have to pay for any compensation when acquiring the land back in the future.
Squatters are humans. They deserve to live side by side with us. They have the right to live and to shelter. Kita jaga kita. Tiba.